नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Blackboard class.
Yes, ma'am.
Yes, ma'am.
All right, good. So the case that we are going to do is Iftikhar Ahmed versus Syed Meherban Ali. Right? Now this is the name of the case that we're going to do, Iftikhar Ahmed versus Syed Meherban Ali. Now the facts of the case are a little complicated, so please understand it very, very carefully. See, this is basically this case relates to the concept that we did in last class, that does res judicata apply between co-plaintiffs and co-defendants also. Those who were not there in the last class, for their benefit I'm explaining it. What it basically means is that if there is a suit which is decided between a plaintiff and a defendant, obviously res judicata applies. However, what happens if there is a suit between people who are co-defendants or co-plaintiff? Does res judicata apply in their context also? This is what we need to find out. So that is why we have this concept of co-plaintiff and co-res judicata. So the answer is yes, that if there is a dispute between co-defendants and co-plaintiffs, then also res judicata applies. However, there are three conditions which need to be met. Now somebody, anyone, please tell me what are these three conditions. Anyone, quickly. Those who...
Ma'am, first there should be a conflict.
Okay, first there has to be conflict is fine, okay. Then?
Next, the conflict has to be decided. And third one is the co-defendant should be a necessary party.
Okay, see, first there has to be a conflict of interest between the co-defendant or co-plaintiff, which means that the defendant or plaintiff who are on one side, there has to be a conflict of interest between these two parties, right? Secondly, these co-plaintiff and co-defendants have to be necessary parties or proper parties. I told you necessary party. Okay, first point का मतलब क्या होता है? There has to be a conflict of interest between the two. What does it mean? This basically means that उनका interest जो है वो adverse होना चाहिए. जैसे कि आप interpleader suit में देखते हैं, तो interpleader suit में we have two or more defendants, but their interest is not the same. Generally, what do we presume? The parties who are on one side, they have the same interest, but that is not the case in interpleader suit. In interpleader suit, the interest of the parties are different from that of the they're conflicting. दो defendant है, एक side है defendant, लेकिन उनका interest तो conflicting है, right? So the issue is that so this is first thing that is required, that there has to be a conflict of interest between these two parties. Second चीज क्या है? That the defendant or the plaintiff that we're talking about have to be necessary or proper parties. The necessary or proper parties we'll do in detail when we do the parties under order 1. But this basically means that these parties are mandatorily required to be there for the proper disposal of the suit. They are required to be there. It is mandatory that they must be there. Right now, third thing that is required is it is required to solve this dispute in order to solve the dispute between the plaintiff or the defendant in order to properly dispose of the case. So these are the three requirements. If these three requirements are met, then res judicata can apply between co-defendant and co-plaintiffs also. So let me start with the case and you will understand it better. So I'm starting with the initial case. Initial case किसके बीच में था? I'm not taking the names because it becomes confusing. So I'm using the terms A, B and C, right? So initially there was a suit between A, B and C. They were the sorry, what am I doing? Wait. Alright. A, B and C were basically the plaintiff and they filed a suit against D. Right? This is suit number 1. Right? What happened in suit number 1? There was a case, in this case, plaintiffs were A, B and C and they filed a suit against D. Right. Now, what was their contention? Their contention was that there is a property that was mortgaged, and this was, see, the kind of dispute you do not have to go into, but the dispute was property was mortgaged, and they were laying claim over that property. That the A, B, and C were descendants of the mortgagors, and D was the mortgagee. So there was basically a dispute regarding the ownership of the property or title over the property, that who is entitled to the right over the property. ठीक है, तो जब ये सूट कोर्ट में गया, तो in this case the D said, look, A is the one who is entitled to this property. A ने जो defendant था, उसने बोला, so look, A is entitled to property. He has a title over the property because this property came from his mother. और जो B और C की मदर थी, they had already relinquished their share in the property. So it is only A who can file a suit against me. Right? So in this case, a decree was given, and what was said in the decree? In this case, in the decree, it was said that this title of the property belongs to A and not to B and C, because B and C's mothers have already relinquished their share in the property. Right? So बाद में जो भी dispute solve हुआ A और D में mortgage को लेकर, that we are not concerned about. लेकिन ये जो सूट था जिसमें A, B, C, three of them were plaintiff, filed a suit against D. In this case, it was decided that A has a title to the property and B and C do not have a title to the property. Is this point clear? Class?
Yes, ma'am. Ma'am, you mean to say that the owner of the property and
yes, A is the owner of the property. It was decided in this case that the title of the property is with A. Fine?
A and A, B, and C, they collectively should be filed a suit against D.
Yes, they collectively filed a suit against D, but it was decided that B and C cannot file a suit because they have no right to property because their mother has already relinquished their share. It was in the course of the case that it was decided that B and C had no right in the property and they had no title in the property. Fine?
Okay.
Alright. Now let's come to suit number 2. Now what happens in suit number 2? In suit number 2, B and C, they go ahead and file a suit against A. Right? Now, B and C filed a suit against A and they claim that we are the co-bhumidars. Right? So, we are the co-bhumidars, which means we are the co-owners of this property and we also have a right over this property. Now, this suit was filed in the civil court. Now, when this suit was filed in the civil court, then what happened? Then the civil court referred this matter to an arbitrator. Now, when the matter went to arbitrator, I told you about the concept of arbitrator, right? Now, when the matter went to arbitrator basically said that, look, this decision has already been taken in the previous suit, which was between A, B, C and D. So, res judicata will apply and it is a very clear-cut position that B and C do not have a right. So, the B and C were not happy with this. They again went to the civil court and said, look, quash this order of arbitrator because it is a failure of justice and all that. So, civil court ne yahi kiya. Civil court has quashed the order. And another arbitrator was appointed and he said, no, res judicata will not apply. Ultimately, the bottom line is, in this case, the civil court held that, through arbitrator, it held that B and C, the res judicata is not going to apply on the second suit because in the previous suit, they were co-plaintiffs and the suit was not between A and B and C, or A on one side and B and C on other side. That's what the civil court said. So, agree, class, you're with me?
Yes, ma'am.
All of you, understanding the point?
मैम ये फैक्ट दोबारा बता दो.
ये फैक्ट सिर्फ ये है.
मैम सूट नंबर 2 से बता दो.
सूट नंबर 2 में क्या हुआ? सूट नंबर 2 में बी और सी ने एक सूट फाइल किया टू द सिविल कोर्ट क्लेमिंग दैट वी आर द को-भूमिदार, व्हिच मींस वी आर द को-ओनर्स ऑफ अ प्रॉपर्टी, जो सिर्फ ए अकेला लेके बैठा है. सो ही इज नॉट द वन हु हैज अ टाइटल, वी आल्सो हैव अ टाइटल टू द प्रॉपर्टी, राइट? व्हेन दिस मैटर वेंट टू Somebody's mic is on, please switch it off. Somebody's mic is on, please switch it off. See, when your mics are on, my voice will start echoing and you'll not be able to hear anything. Okay, so in this case, the basic issue that was there was that we are the co-bhumidars. So the civil court में basically जब court case गया, तो through arbitrator it was decided that res judicata is not going to apply on the second suit because first suit was not between B, C on one side and A on one side, but it was between A, B, C on one side and D on other side. Are you getting it? Class.
Yes, ma'am.
Everybody. और सिर्फ ये कहा कि सूट इनके बीच में नहीं था, ठीक है? Okay. Now what happened? Aggrieved by this decision that res judicata will not apply, A went into appeal. Now he went in appeal to the district court. District court ने कहा res judicata is definitely going to apply. There is, district court said that obviously they are co-plaintiffs, so res judicata principle will apply on co-plaintiffs, and the interests were also adverse. So we need to find basically three requirements when we look at whether res judicata will apply on co-defendants and co-plaintiffs or not. And these three requirements are given in para 9. If you have the judgment with you, it would be in para 9. Let me see if I can open the judgment. Let me see, wait. Let me try and share the judgment also with you. Okay, I've got the judgment. Okay, para 9 is here. Alright. Let me can you see my screen? Can you see the class?
Yes, ma'am. Yes, ma'am. Yes, ma'am.
Can you see the judgment? Can you see the judgment that I've shared?
Yes, ma'am. Yes, ma'am.
Alright. So you can see para 9 in it. See, para 9 basically say now it is settled by large. It says that, okay, let me. Alright. Now what does it say? It said it is a settled, now it is settled by large number of decisions that for a judgment to operate a res judicata between or amongst co-defendants, and it also applies to co-plaintiffs, it is necessary to establish three things. Now what are the things that needs to be established? First, that there has been a conflict of interest between the defendants. Second, that it was necessary to decide the conflict in order to give relief to the plaintiff claimed in the suit. And third, that the suit actually decided the question, right? So these three things are essential when it comes to applying res judicata between co-defendants and co-plaintiffs, right, class? So let's go back to our question. Now, so in this case, when we come back to this case, the district judge said that, look, if we look at all these three conditions, definitely these are co-plaintiffs. Their interests are conflicting. Why the interests are conflicting? Because C is having title to the property and B and C are not having the title to the property, right? And is it necessary to decide this conflict? Yes. Is it necessary? Are they proper parties? Yes, they are proper parties. And was the matter heard and finally decided? Yes, in the previous suit, the matter was heard and finally decided. So on the basis of this, the court, the district judge came to the conclusion that yes, res judicata will apply in the second suit also. Then they went in appeal to the High Court. Now B and C went in appeal to the High Court. Now when B and C went in appeal to the High Court, they found that High Court said no, res judicata will not apply because since they were parties on one side only. Again, the matter went to Supreme Court. Now, when the matter went to the Supreme Court clarified the situation that look, the High Court and the Civil Court have been wrong in saying that res judicata will not apply, since all the three requirements of res judicata are falling in all the three requirements are fulfilled. So res judicata will apply here also, and B and C would be barred from the court would be barred from proceeding with this case. Right, class? So is this case clear, class? Class, tell me.
Yes, ma'am. Yes, ma'am. That's the doubt.
Okay, ask.
Ma'am, the decision that was the first decision in which ABC claimed the property against the D, so that was the arbitrator's decision. And then
that
all
was
the
not
other
arbitrator's. See, that was an arbitrator's decision, but later arbitrator award needs to be confirmed by the court. So it is as good as a court's decision, basically. It was given for arbitration, but it was confirmed by the court, so it's as good as a civil court's decision.
And then all the other decisions that came, they were directly contested
They were court
in the
decisions.
courts only. Oh.
Court, because it was an appeal that whether res judicata is going to apply or not. Right?
Thank you, ma'am. Yeah.
All right, welcome. So, since res judicata topic is over, so what we are going to do now is we are going to start with. We are going to start with suit by or against the government. Now, suit by or against the government is dealt with in section 879 and 80. Now, if you open, you're having a beret, or should I share the beret with you?
No, we are having.
You're having? Okay.
We have.
Okay, good,
Yes,
good, good. So if you're having good, well and good. So what we're going to do today is suit by or against the government. See, one thing that you need to understand beforehand is that when we talk about suit by or against the government, why is it that we have some kind of special provisions that we have for government that we do not have for a private individual? And what is the special provision that has been given in section 79 and 80? That is the provision of notice. Right? What do you mean by notice? Notice is that before a person can go ahead and file a suit against the government, then what is required is before filing a suit against the government, the person is required to give a notice to the government that look, I'm going to go ahead and file a suit against you. So it is better you resolve. Not better. Better is like very intimidating kind of term. So that is not what they use, but they say that please resolve my dispute here only so that I do not have to go to the court. Now, why is it that we have a special provision in the case of government that is not there in the case of a private individual? The reason being that, look, when it comes to private individual, the interest of both individuals are involved. Both of them will be equally kind of troubled by the litigation being filed. However, when it comes to government or when it comes to suit against the government is for everybody. Government is a government department, so nobody is personally involved. Even the official against whom you are filing a suit, it is not in his official capacity. It is in his capacity as that official. और उसका transfer हो जाएगा तो जो उसकी जगह आएगा वो suit को continue करेगा, right? So nobody takes a personal interest in the suits which are government suits. Government के suit बहुत सारे चलते रहते हैं, right? So since this is the rationale, why do we have this provision where it is required that in case you're filing a suit against the government should be given a notice, क्योंकि government पहले ही इस issue को resolve कर ले, so that you do not have to go to the court, and so much of money, public money is also going to be wasted if you file a suit against the government. Then ultimately किसका पैसा जाएगा? Ultimately it's our money only. When we pay taxes, government is going to hire lawyers from that money only, and the public money is going to be utilized in all these suits. So that is why, to save that the time of the government, the energy, the money, and also to give quick relief to the person, agreed party, there is a provision of giving notice because. Right, so that is a provision. So let me read out the provisions. We have section 79 and we have section 80. What does section 79 say? Section 79 says suits by or against the government, right? So section 79 basically tells you when a suit is filed by or against the government, then what is the terminology, what is the phrase, that what is the name, by which name do we file a suit, right? So section 79 says suit by or against the government. In a suit by or against the government, the authority to be named as plaintiff or defendant as the case may be shall, क्या नाम होगा उनका? A. In case of suit by or against the central government, the Union of India, right? So if you're filing a suit against the central government, it would be Sneh Yadav versus Union of India. या फिर if the government is filing suit against me, it would be Union of India versus Sneh Yadav, right? So the term which is going to be used is going to be Union of India. What happens is that these are all basic things, you already know it, but since we have a provision, I'm explaining it. Now, B main. In case of a suit by or against the state government, the state, right? For example, state of Madhya Pradesh versus Iftikhar Ali, right? So we have the name of the state. Clear, class?
Yes, ma'am.
All right. Now let's come to section 80. Section 80 basically talks about the notice part. What does section 80 says? Section 80 says, save as otherwise provided in subsection 2, no suit shall be instituted against the government, including the government of state of Jammu and Kashmir, or against a public officer in respect to any act purporting to be done by such public officer in his official capacity. Please underline these terms, that the word, when we are talking about suit against the government, we are referring to the suit against the government for the work that has been done by a public official in his official capacity, right? I'll give an example and explain it later. Just continue with this, right? Okay, an act purporting to be done by such public servant in his official capacity until the expiration of 2 months next after the notice in writing has been delivered to or left at the office of. अब कहाँ notice देना मैं बताती हूँ, लेकिन उससे पहले just understand. When we talk about section 80, what we are basically referring to is that before any individual is going ahead and filing a suit against the government, in that case they have to give a notice to the government if the matter relates to something which has been done by a person in his official capacity. Now, please, I've told you about the titles and capacity. A title and capacity of a person can be different, and so the rights, liabilities, responsibilities is also going to be different according to the title, right? For example, if there is an official and he commits the offense of theft in his private capacity, right? Yeah, he commits the offense of, let's say, sexual assault or rape or whatever. Then is it required for to prosecute this person, we have to give the government 20 days note? या फिर कोई civil offense भी करता है, मान लीजिए अपनी private capacity में वो breach of contract करता है, ठीक है? As a private individual, he is buying a house and or he's selling a land and he takes the money but does not give the land. That is his private, in his personal capacity. Is it required for the person who wants to institute the suit to give a notice? Tell me, class.
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें। थैंक्स फॉर वॉचिंग।